Governor has been barred from accessing his office. Another deputy governor could now take charge of a county. One has said he's actually in charge of a county now. Another decision whose implications transcend Kiambu County and cause jitters among state and public officers who are now literally walking on thin ice. Kiambu Governor Ferdinand Waititu has been barred from accessing his office after he was charged with corruption. That decision, an outcome of an application by the DPP and informed by an earlier ruling by High Court Judge Mumbi Rule, who barred Samburu Governor Moses Leonard Kulal, also charged with corruption, from accessing office. We'll look at the implications now, good or bad, depending on how you look at it, with advocates of the High Court, Nelson Harvey and Charles Kanjama, and the National Coordinator of the Institute of Social Accountability, TISA, that is Wanjiru Gikonyo. Thank you all for making time for us tonight. Text us 22422, on Twitter is the hashtag NEWSNIGHT. We'll sample a few tweets very quickly before we begin. Do we have them? Okay, this is Kipchumba Murkomen, who says, it seems by the end of the year, all 47 governors will have been charged in court. Going by the decision of Justice Mumbi Rule, it is the greatest time to be a deputy governor. You just fix your boss and voila, you take over. Being DG in Kenya is not bad after all. And then we have Ahmed Nasir Abdullahi, Senior Counsel, saying, since Babayao is barred from accessing the governor's office in Kiambu, I offer the considered legal opinion that he can open a new office in Limuru or Thika or Gatundu or Kikuyu or Kiamba and continue discharging his constitutional duties as governor of Kiambu. Okay. Another tweet here, we have Haman Manyora. I will go with the opinion of Professor Makao Mutua that Governor Babayao should resign. He's been disgraced enough and should spare the people of Kiambu the shame of having to refer to him as their governor. Right, and finally we have Senator Ledama Olekina. So does it mean we will also see the arrest on Ruaraka land saga? DCI Kenya, ODPP, citizen, okay, you copy all those. You're saying, I'm sure, is that what you're saying? I sure do hope, sorry, we are not going to be selective for the war against corruption. Okay, keep texting us, as I said, 22422 on Twitter is the hashtag NEWSNIGHT. We already talked about, and it's time to explain what you all said earlier about when Deputy Governor Dr. James Nyoro said he's now taking over. First of all, so is Waititu still an active governor of Kiambu County? I'll start with you, Charles Kanjama.
I think there's been confusion as to the orders of the court, both in the case of Governor Waititu and Governor Leonard Kulal of Samburu County. The court gave conditions for granting bail. And the condition was that there should be no access to the physical offices or interference with the witnesses. So this did not amount to a suspension. And in fact, Justice Mumbi Rule, when she was discussing the matter of Governor Leonard Kulal, explained that according to her, even though she thought a suspension would be acceptable, the orders of the trial court were not a suspension, but merely a restriction from physically accessing the offices. So my reading of the ruling of Justice Mumbi Rule is that the governors are still entitled to continue discharging the functions of their office, so long as, one, they don't physically access those offices where the county government offices are, and two, they have no contact with any of the people who may be witnesses in the trials against them.
And who would decide that? That's the funny thing. Because, okay, I'll give you an example. At some point, I think last year, Governor Sonko was operating from Machakos when he said his life is in danger.
Yes. So
this can happen. That's what you're saying. If Waititu, and you've seen so many people talking about this, if Governor Waititu decides to go somewhere else or operate from home, he still discharges duties as governor. That's what you're saying.
Yes.
Regardless of who is contacting or...
So long as he doesn't contact a witness. If none of the cabinet secretaries, the CECs, if none of the CECs are a witness, he can even carry out a cabinet meeting. If some of them are witnesses, then he'll have to have a meeting with part of his cabinet.
Is that possible, or does this ineffectively mean you're out?
Hussein, if I decide to embark on a career in crime, this is my lawyer, because I think he can turn anything. Well, I think the judge was very clear, because she said, she first started with Article 1 on sovereignty. And this is where Justice Mumbi took us. Article 1 vests the power in the people of Kenya which is exercised by the legislature, lawmakers, on behalf of the people. That's where she started. And she said she is sure that the people of Kenya did not intend that these lawmakers would then pass a law that undermines Article 10. So she moved from Article 1, which is a very strong article, to Article 10 on national values, and said national values are very clear on matters of integrity. And then she went further to link that to the Act. This article, Section 62 of the Act, Anti-Corruption and Economic Crimes Act, and said that public officers are required to step aside if they are caught, if they are charged with economic crimes, or if they are charged with criminal matters, they are required to step aside. So she said she is sure that when people vested authority in their lawmakers, they did not intend that lawmakers will set a lower standard for state officers. And note, she said state officers, which means it's not just governors, it also applies to all other state officers who are indicted, charged with a crime. And they are, therefore she has now set a new standard. So I don't agree that we can play some games geographically, much as I would maybe look for a lawyer who can argue that way. The judge was very clear that the spirit and the letter of the law is that people wanted leaders who engage in corruption should step aside.
For the sake of our viewers, let's just take a look at that Act, Anti-Corruption and Economic Crimes Act, what you just talked about. And that is 62. That is suspension if charged with corruption or economic crimes. That is for state and public officers. Generally, it talks about suspension. Once you're charged, that is, you're suspended at half pay and you'll get your full allowances, provided the case is to be determined in 24 months. That is 2 years. And one will resume office after acquittal or dismissal. But that specific article you're talking about, 62.6, which says this section does not apply with respect to an office if the Constitution limits or provides for the grounds upon which a holder of the office may be removed or the circumstances in which the office must be vacated. For example, governors, which is provided for in Article 182. And then I'll quote what Justice Mumbi Rule said, and I quote her, it seems to me that the provisions of Section 62.6 are contrary to the constitutional requirements of integrity in governance, are against the national values and principles of governance and the principles of leadership and integrity in Chapter 6, and undermine the prosecution of officers in the position of the applicant in this case. In so doing, they entrench corruption and impunity in the land. How do you read that, Nelson Harvey?
Now, let me start from what my two friends have just discussed. In my honest opinion, I think Deputy Governor Nyoro is a not so witty beneficiary of misinformation by the media as to the scope of the decision by Justice Ngugi, as well as the decision by Honorable Mugambe. Honorable Mugambe has not precluded Governor Waititu from exercising his function and duties as governor of Kiambu County. But more importantly, even Justice Mumbi Ngugi herself did not declare as unconstitutional Section 62, subsection 6 of the Anti-Corruption and Economic Crimes Act, for two reasons. First of all, the question was not before her for determination. And the second reason, she could not make such a determination on a limited scope of jurisdiction under the manner in which she was approached. So if you look at it from that point of view, you realize the manner in which judicial activism of the kind that we are now saying can impair the well set out mechanism of devolution and government at the county level as intended by the Constitution. And this is not to say that we are here to support state officers who are corrupt, but we insist that there must be the rule of law. And the rule of law can only be defined by what is set out in statutes and the Constitution. It follows, therefore, that any interpretation that the people of Kenya could not have intended that an elected governor should be given preferential treatment to a permanent secretary or a cabinet secretary. It is not a question really for the court to determine. And if I dare say, we've been through this debate much earlier when many elected leaders said, It is not the function of the courts to determine the will of the people. The will of the people is determined by the people themselves.
And you are frowning, Wanjiru.
Completely. And of course, the courts are very, very important in the implementation of the Constitution. In fact, we borrowed significant, the architecture of devolution, for instance, from South Africa. And if you look at the South African example, with their constitution, they have a constitutional court. And during the transition period, where they were transiting from their old constitution to the new constitution, the courts had to approve all the laws that were drafted by the legislature. They had to be approved by the Constitutional Court. Why? Because of political interests that are likely to come into play, and because it's presumed that the court is going to bring much more objective reasoning that balances out, because these are all separate arms of government. So there are checks and balances structured into a democratic process for a reason. In Kenya's case, we need the courts because the courts are actually right now our last bastion of hope against what has really become a very power-crazed parliament that has done very few good things, but very many bad things with the very strong powers that they have been given. Another example on how they've diluted provisions that have to do with accountability is the article on recall. The Constitution gives Kenyans the power to recall their elected members if they do not perform. But in drafting the law, the legislature deliberately made it almost impossible to recall your legislator, whether it's an MP or at whatever level. The courts were then forced again to say that that law, that statute is unconstitutional. So I do not agree that we are governed by the Constitution and statute on equal level. I think I'm not a lawyer, but the lawyers are deceiving us.
And of course, for the record,
there's a hierarchy. There's a hierarchy.
Honorable Waititu's lawyer in this specific...
So I'll be careful when I speak. I'll be very careful.
So you said earlier that this is actually a coup.
Yes, it is a coup.
So, I mean, according to you, because Kanjama was talking about, it is just barring him from his office, as long as he doesn't interfere with witnesses and so and so. To you, what is it then? Is he still the acting governor of Kiambu County? Does it matter that he can open an office elsewhere or operate from home?
Well, you've seen suggestions from our learned colleague that is what he should do. But in actual fact, is that what he's supposed to do? In my opinion, no. Reason being, first, the decision by the magistrate has not stopped him from exercising his functions as a governor.
But it has stopped you from accessing your office?
Yes, it has stopped him from accessing his office. Yeah. Now, therein lies the mischief. And that is the reason as to why I insist it may appear to be a judicially facilitated coup. And it's not more than 5 hours before the deputy assumed power. And if anything is to go by, you can see the pandemonium that is likely to ensue because of the misinterpretation of the decision of the magistrate as well as the decision of the judge of the High Court.
Charles, do you wish to still say something on that? It's still not clear. Many people are talking about this. What does barring you, is it about semantics? What does barring you from office mean? Are you ineffectively not the governor anymore? I mean,
allow me to say a few things. First of all, the judgment or the ruling of Justice Mumbi Rule, I think, was clear. She upheld the ruling of the magistrate who granted bail terms to Honorable Lennon Kulal of Samburu County.
Yes.
And those bail terms were very clear that he should not access the offices or talk to any of the witnesses. Justice Mumbi Rule, however, beyond the order she gave, she engaged in what we could call obiter dicta as lawyers, which means she started having a discussion, which was not the decision she made. It was a by-the-way discussion as to what she thinks is the appropriate course of action. So what has happened is that several non-lawyers and also some of my lawyer friends seem to be treating her obiter dicta as the decision she made. And in her obiter dicta, she actually thought that Section 62(6) of the Anti-Corruption and Economic Crimes Act is not constitutional. That was obiter. It was not a finding that she made. Personally, I've reviewed that part of her reasoning, and I'm a bit concerned because she is the same judge as one of the 5 judges who passed a decision just a few weeks ago in the case of Deputy Chief Justice Philomena Mwilu. And in that case, the judges seemed to be very sensitive about the need to preserve other arms and organs of government that are independent from executive interference in their independence. In fact, when you read those two, the judgment of the 5 judges and this ruling, you get a bit perplexed at the divergence in reasoning of the two. And my question is this: if judges have security of tenure, in other words, they can only be removed using a certain constitutional mechanism, and it is deserving of protection by the judges, how come they do not think that any of the other office bearers who the Constitution has also given security of tenure are deserving of the same principles? And then I've been a bit concerned, and I think this is something that great jurists like Judge Albie Sachs of South Africa have talked about, the question of presumption of innocence. When you read keenly the ruling of Justice Mumbi, you notice she's already considering Honorable Lenol Kulal as, because of having been charged, as being morally ill health. In other words, it's almost as if you've been convicted. When you read the rulings of the magistrates, it's the same way. They are reasoning in the same way. And yet, this is the first principle in the Constitution, in Article 50, paragraph 2, on the right to fair hearing, to be presumed innocent until proven guilty. So it seems there are two ways of thinking.
How does this affect that principle, innocent until proven guilty? And then again, how much is it prone to political witch hunt? Especially, we've seen the problems with governors and their deputies.
Now I'll come into that from a social accountability point of view, and before I get to that, I'll just say, when you talk about judicial activism, this is a term that's been used quite a lot around the Constitution, and our position is that the Constitution is a peaceful revolution. It's a negotiation between the people of Kenya that sought to undo the traditional bastions of elite self-interest and state capture. That's what the Constitution is not a harmless document that wants to preserve a status quo. It came in to change the status quo, vest sovereignty in the people, and place accountability and integrity on the leaders. Now, how do you exercise that integrity and accountability and respect the rights of those leaders? Yes, because that presumption of innocence is very important. However, stepping aside, when you are charged with a crime, does not presume you to be guilty. All it does is prevent you from manipulating the tampering with witnesses, manipulating the process, and also upholding the principles of Article 6 of Chapter 6. Because Chapter 6 is very clear that in conduct you must be seen and you must conduct yourself in a way that's befitting for that high office. We must remember, a state officer is not just a governor. There are very many other officers who fall under the category of state officers, and according to Justice Mogegoge, this ruling applies to all those state officers. So the idea is that we should not exempt state officers from the accountability that's presently exacted or expected from public officers.
And she also said, would it serve the public interest for him, that is Governor Lenol Kulal, to go back to office and preside over the finances of the county that he has been charged with embezzling from? What message does it send to the citizens if their leaders are charged with serious corruption offences and are in office the following day, overseeing the affairs of the institution? How effective will prosecution of such state officers be when their subordinates who are likely to be witnesses are under the direct control of the indicted officer? Of course, you're arguing against this, but I'll just want you to respond to that. Well, especially in this war against corruption.
Again, that is the point in time where Justice Mumbi Ngugi veers off the rail, because she proceeds to say that these governors will continue enjoying the trappings of power. She fails to appreciate a very fundamental aspect of the responsibility of a governor. The governor is not just in office to enjoy the trappings of power. The governor has duties and functions given to him by the Constitution and statute, as well as the mandate of the people who elected him. Yeah. And until such a time as the governor has been found to have misappropriated funds, to have abused his office, and this can only result out of a conviction. Now, if you look at it in that perspective, you realize how such a sweeping statements before the trial of a matter can have a very adverse impact. And in this particular case, we are no longer talking about this issue as if it's the realm of conjecture, because it's now obvious that somebody has misinterpreted both her decision as well as the decision peculiar to Governor Waititu as giving him the power to take over office, as if the governor has ceased acting as governor.
Of course, they did not specifically talk about that.
Yes.
About giving or removing. They did not put themselves under just that jurisdiction, removing Waititu from office. That was very clear.
No. If you listen to the press statement,
that is political. That is Dr. James Nyoro saying he's taking over. But that wasn't from the courts.
Saying you need to understand that administration and politics does not exist in a vacuum. You understand? It is based upon certain principles of law, which these leaders tend to interpret based upon advice either from their legal advisors
or otherwise,
or from the public opinion.
But political interpretation cannot be blamed on judges' decision. That you cannot do.
No, of course.
You cannot even accuse them of working together.
No. We cannot accuse the judge of being the source of this. But the judge also has a responsibility of ensuring that the manner in which she expresses her opinion is not misinterpreted by legal practitioners or by the public. Because in this particular case, as you can see, not only the press and the people who claim to be behind Governor Nyoro, Deputy Governor Nyoro, but also if you go to the Twitter handle of the DPP, it seems to have come to the conclusion that the decision by Mumbi Gugi has effectively stopped governors who are charged from exercising their functions as given by the Constitution and statute.
And many people, including both of you tonight, that's the question I kept on asking. Of course, what Jiru here says is he's no longer the governor. That's what you believe, right?
That's what I was talking about.
You also believe the same.
No, I don't believe the same. I believe that the people have been misinformed because of the manner in which the decision
but I'm just wondering
has been expressed.
I'm just wondering if you have been told not to access your office, what else is left for you to do as a governor? I mean, and as you respond to that, this is the last question, or two, for all of you. One, what kind of powers now rest with the DPP? Because it's about charging a state or public officer. How healthy is that? With all those powers the DPP will now have, people would think it has now, because all you need to do, if we use this as a precedent, is to just charge you, and then you'll have to be barred for now from accessing office.
Let me start by saying that when you read the Constitution and study it, you discover it has a constitutional architecture that was meant to immunize the legal decision of the DPP, which was meant to be based only on facts and evidence, from politics, and to provide other bodies with the job, which was both legal and political, of determining whether to remove elected officers. And in the case of governors, this is in Article 181 and 182 of the Constitution. The job is given to the County Assembly and the Senate, which are able to utilize both legal and political arguments, whether in advance of a trial or after a trial, the moment they think there has been misconduct by a governor. So by the decision that has been made by Justice Mumbi Ngugi, what it is doing is that it is going to create a politicization of the office of the DPP, which would mean that every time the DPP decides to charge someone, there is a political implication that he is the one deciding on. Is not another body that has been given the job by the Constitution. So there is a danger there, which I think the judges in the Justice Mwilu judgment recognized, But Judge Ngugi, in this particular judgment, was not alive to.
Very briefly,
yeah, I don't agree that this judgment is a ruling against devolution. This judgment is a ruling against corruption. What Justice Ngugi has sought to do is give life to the values and the principles of the Constitution, which are especially those which are articulated in Chapter 6. And this will set a standard, will set norms, whereby when somebody is running for elective office, they have to be eligible. If this ruling had been in force, this standard had been in force, the IEBC would then not qualify people who are charged to run for government. Yes.
All right.
To run for political office.
The decision by Justice Ngugi has actually jettisoned the rule of law so far as criminal practice is concerned. Because in essence, therefore, it means that any suspect who has been arraigned in court will cease holding office that has either been given to him or her by the people through a process of a free and fair election. And that was not the contemplation of the Constitution.
All right. Thank you all for making time for us. And I wish we had more time, but obviously this is huge and the implications are huge, and I'm sure we'll be having these discussions again. Honorable Kabogo is texted and says, I warned the people that the guy was coming to steal our resources, but they did not heed. Sasa wanalilia kwa choo. Okay, that is still not convicted. These are allegations. He's just misjudged. Then the people of Kiambu should now pick it up from here and make sure from now on it's the fast lane. 2 years we have lost, but it's all lost. Deputy Governor should take over and take the county to the next level, or else the same fate. And Governor Obado says, hi Hussein, I've never been charged with any graft charge in any court in our country. There are people who would be very happy to find just anything, whatever it is, to incriminate me. So far, nothing. Keep texting us, 22422, or SMS number on Twitter is the #NewsNight. And still ahead.